Domina, you may approach. Good morning to you. You may proceed.
Thank you, Your Honor. Good morning. May it please the Court, I'm Dave Domina. I'm here on behalf of DMK Biodiesel and Lanoha Biofuels. My clients filed a complaint in district court alleging that they were the victims of securities fraud. They invoked the state securities statute. That statute in section 8-1118, parts 1 and 5, contains two fundamental provisions upon which they rely. The first is this: if any document associated with the sale of securities violates the Securities Act, it is void. And the second is, anyone who makes a false or misleading statement in connection with the sale of securities is liable to the investor. The trial court dismissed our complaint on a motion to dismiss. It had in the court file at the time of its ruling 130 pages of material attached to the motion to dismiss. Its order of dismissal is unclear about what procedure was adopted, whether it treated the ruling, the motion, and therefore the ruling it had to make as one for summary judgment or as one for dismissal. It acknowledged the receipt of extraneous evidence. It announced that it thought that the material considered was implicit to the claim we asserted, and the trial court thought it could consider the material attached to the motion to dismiss on that basis under the judicial notice statute. Before the court's ruling, the plaintiff's lawyer, me, requested that the court not take judicial notice, allow discovery, there had been none or substantially none, treat the matter as a motion for summary judgment if it was going to consider extraneous evidence, and give us a hearing.
The extraneous evidence, was that the private agreement or was there other evidence?
It is nearly all the private placement memorandum, and I think it's sufficient to say for our purposes today that's really all that counts. There is more data attached in the file, but I'm not concerned about it.
Is there a subscription agreement?
There's a subscription agreement also, Your Honor, but it really is within the private placement memorandum. It is signed. The signature would be in addition, and the recitations are also a part of the private placement.
So the investors made some representations in connection with the documents they signed?
They signed the subscription agreement, which contains representations. Now,
did you actually ask for a hearing?
yes, we did. We filed a motion requesting a hearing, Your Honor, and we got no response to that except that several months later we got the order of dismissal. And that request for a hearing is on pages 321 and 322 of the record. Now, our position procedurally is pretty simple. The material judicially noticed was not appropriate for judicial notice. These are private contract documents. They're not filed in a government office. They're not the kind of information that can be verified or confirmed by general reference in the jurisdiction to known information or knowledge. It's simply not Rule 27104 material. In addition, we're entitled to a hearing on the question of whether judicial notice should be taken. The appellees suggest that we should have requested the hearing after the order of dismissal came down.
What is your authority for you are entitled to a hearing?
The statute itself actually says that affirmatively on its face, that upon request, a party is entitled to a hearing on the question of whether judicial notice is proper, and where the request follows the ruling, the hearing can be held after the fact, asking the judge to revisit the issue. I think our problem here is that the judge gave us permission to amend, dismissed our direct claims. We had both direct and derivative claims, and we're here on the direct claims. So we had the request before him, before the ruling. He ruled. We satisfied the statutory requirement. We were entitled to the hearing, and we didn't get it. So I think there's a serious procedural flaw. That's half of it. The other half of it is that because this data was the kind that had to be, at a minimum, judicially noticed, it was clearly extraneous to the pleadings, and unless this court finds that it's necessarily implicated in the complaint, it's summary judgment material, and we were entitled to put on contrary evidence. When you take a look in the record at pages 321 and 322, you'll see that in that filing, I listed the evidence that we would offer at the hearing that we requested. 3 specific pieces of evidence, including affidavit evidence, which we were never given an opportunity to offer. So procedurally, there's a flaw that we think compels and requires reversal. But I want to talk about the substance of the case too, because I think that on remand, we have a ripe issue for you to consider substantively, and we want you to decide it.
Could I, before you go there,
Yes, Your Honor.
going back to this motion that you've been discussing, it actually includes a notice of hearing, which says that the motion will be called up for hearing on March 13th, 2009. Did that ever happen?
There is no record of any such hearing. There was a congregational meeting at the courthouse without a court reporter,
Okay.
and there was no evidence offered or received. Now, may I go to the substantive issue for just a few moments? Your Honor, as we raise in our brief, we believe the Securities Act, Nebraska's State Securities Act, has no reliance element for a securities fraud claim. We think the trial court did not perceive correctly that that's the case. The statute says that if a seller of securities commits securities fraud, an act in violation of the statute, the seller is liable. It does not say the seller is liable if the proximate result is investment. That's, we believe, the federal rule, but not the blue sky law rule adopted in Nebraska. We cite Arizona and California cases with similar statutes that reach that conclusion. We acknowledge this is an issue of first impression for you. We can find nothing that addresses that question, although you have said several times that the Securities Act's purpose is to protect investors, not promoters, so that the doubt goes to the investor. And in this case, we have a situation in which we contend that the items listed in the prospectus, recited in the subscription agreement, are palpably false, and they include material misrepresentations like, we own real estate, we have a bank financing commitment, which turned out to be not true. We contend that the prospectus representation should be ignored, that the subscription agreement should be declared void, and we should get to put on our proof. And when we do, if we prove falsity plus investment, we need not prove reliance in order to prevail. So we request that you reverse and remand on that basis. Thank you.
Thank you. Mr. Grouse?